Alex here with part 161 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains a detailed disclaimer and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go now into my ex's attorney's motion to strike writ of execution. The mindset here is the exact same mindset as the previous video. In fact, this document is going to mostly be a clone of the previous document that my ex's attorney has filed. The previous document was opposing her being subjected to a debtor's exam, and this document is trying to quash a writ of execution issued by the court. Both of them are based on the exact same arguments. So don't be surprised if most of the document is, scrolled through very quickly. Anything that I identify to be a, just regurgitation of what was in the previous document, I'm going to go ahead and move through swiftly. And as with my previous videos in the My Docket series, you can always go down in the description below, click on the link, download the document for yourself, take a close look. And if you think that there's something that I missed or should have talked about, definitely post something down in the comments and I will go ahead and address that. The last thing that I want to mention is there will be a second document in this video, which is the notice of compliance. And this one I'm going to spend a little bit more time on because this covers my ability to relocate to Vegas after graduating. All of that being said, let's go ahead and take a look at what my ex's attorney has filed. Here we have my ex's attorney's motion to strike and render writ of execution void. I think that this should have been called a motion to quash writ of execution. I think that's how it works, but I'm not sure. In any event, a motion to strike is appropriate in this case. I know I have said that this doesn't make any sense when you try to use it for under certain circumstances. For example, when you try to strike another motion, stuff like that, and it has to do with the timelines and deadlines. But trying to strike a writ of execution actually makes sense. So I'm not going to really say anything, negative about that. I just think that usually this is something that they'll refer to as a quash. In any event, standard introductory paragraph, he indicates that he is representing my ex and that she is trying to get rid of the writ of execution that I filed, which is trying to seize her assets. Next page is just a signature, and we go into the points and authorities. Same thing, guys. This is all duplicate. Duplicate, $50 check, the letter he sent. Writ of execution to be stricken and void. Okay, this looks different. NRCP 11. So Rule 11 provides that any pleading, written motion, or other paper shall be signed by at least one attorney of record in the attorney's individual name, or if the party. So he's trying to say that I signed the writ of execution and that therefore it's not valid. I don't think that this makes any sense though, because the writ of execution is issued by the clerk of the court. So, is he trying to say that my attorney has to sign the writ of execution? That doesn't sound right to me. This is shady for another reason. This is so disingenuous. It's no wonder he was able to trick the judge so well. So Rule 11 and Local Rule 23 cover that attorneys have to sign documents that are filed in a case, otherwise it's a fugitive pleading. That's true if it's a paper or other document that's filed. But like I was telling you guys, writs of execution are issued by the clerks of the court, not by attorneys. So that makes me suspect that he's completely wrong. The Supreme Court is not amused by this either. They reject this, and they, maybe this is not what the court issues sanctions on. So that might be why that wasn't brought up on appeal. That's possibly why. I don't know, guys. I have a lot of doubts about this because it's a document that's not even issued by me anyway. Next assertion here. As the clerk is well aware, I am represented by counsel in this matter, and that I filed a writ of execution myself in the matter. Not only must all documents be signed. Okay, so again, he's usually right about this. The only thing that I'm thinking he's wrong about is the fact that it was a writ of execution. If it wasn't for that, then I would say he's right and I shouldn't have done that. And you guys shouldn't do that. If you have an attorney of record, you shouldn't be filing documents in the case. But there's nothing that stops clerks from issuing documents. You can ask for it to be issued without your attorney's consent because it's not you that's issuing it. Writs of execution are not supervised by the court. These are you having already won your case, trying to collect on your judgment. It sounds strange to me that he thinks an attorney should have to supervise this part of the process because the attorney's role is done. They've already won. It's over. It's done. You're just trying to get your money. So, I mean, this is just him grasping at straws and trying to make me look like a bad person again. If you read this, that's what he's trying to do. The writ of execution is contrary to the court's order. Okay, so this is him using the same authority as before. He's trying to say that because my ex has to pay $50 per month, that I'm not allowed to execute on the judgment. I've already mentioned to you guys that I'm very suspicious that this kind of stuff, I highly doubt that this is possible. I've talked about how the courts should not intervene in the execution and asset seizure process because that would be in violation of the legislature's intent with regards to how execution on judgments is supposed to work. So I know that in some states they do allow the courts to supervise the process, for example, Rhode Island, but as far as I know, Nevada does not allow this. All this is the same argument as before. And my ex, okay, so she's requesting attorney fees again, and this is the same arguments as before. None of this is new, guys. Same exact arguments, same exact conclusion, same exact affirmation. None of this is new. Certificate of service is the same, indicating that he mailed this to my attorney. This should be the same as well. No costs on filing this document. The letter is going to be the same, guys. So I'm going to go ahead and stop scrolling because this is the exact same letter as the previous letter. He's just using it for this document as well. Next document is the Notice of Compliance with Relocation Requirements and Establishment of Alternative Visitation Schedule. So this is me complying with the court's order, which is to show that I have graduated and that I am giving my ex an alternative visitation schedule. So at the hearing on November 4th, I requested permission to relocate to Las Vegas. The court said that I could do so by being accepted to Boyd School of Law, or that I can secure employment in Las Vegas, Nevada. I got an offer of employment from Telecom North America. I graduated with my degree of computer science and engineering. Yay! So I'm basically saying, hey, I got a job, I graduated, and I'm out of here. I've complied with the court's order. The alternative visitation plan is as follows: that my ex shall have our son during winter, spring, and summer breaks for a total of no more than 52 days each year. That's simple. Claiming visitation periods is the same as claiming vacation. We have a procedure in place for claiming vacations. You send me notice. You have to give me advance notice. I think it's supposed to be 14 days, but it looks like I'm giving her just 7 days notice, or I'm allowing her to give me just 7 days notice. And if she does that, she gets our son. Just that simple. She's limited to 52 days because that's what she has already. And now instead of getting that every other weekend, she can lump it together in blocks of time. She could be like, hey, I want to get 52 days, in a row or something like that. I think there are limits. Let me see here. Are there limits to how many? Okay, it looks like, okay, there are some boundaries. So no less than 2 days and no more than 21 days. The 21 days makes sense because if she gets too much time in a row, she's going to cause damage to his teeth. So, I mean, it's still going to cause a lot of damage given 21 days, but at least I have him most of the year. So, I mean, it's the best I can do given the fact that she has a right to see him. And then we have some prohibitions so that I can at least have some Christmases and Thanksgivings. Transportation costs are covered as well. And these are basically allowing her to claim airfare and or transportation via car. So if you guys want to read these, you can go ahead and do that. There's nothing really legal that jumps out at me that makes me want to spend a lot of time on this. Mainly, I wanted to let you guys know that I did comply with the court's order, that I relocated to Las Vegas, that I graduated with a computer science and engineering degree, and that I got a job. Rule 5 Certificate of Service indicating that this document was mailed to my ex's attorney. List of exhibits, we have 2 things. Number 1, we have my offer of employment from Telna. And as you can see, I am no longer going to be a poor college student. I mean, this is pretty good for entry-level software engineering. I also got relocation expenses for moving. And Exhibit 2 is going to be my diploma. Computer Science and Engineering, bachelor's degree. Fantastic. Going into the aftermath, my ex's attorney, I filed 1 document, but it was a free filing, so I incurred $0 in costs. My ex's attorney filed 1 document, also a free filing, so she incurred $0 in costs. I had an attorney who represented me for free, so I incurred $0 in attorney fees. My ex's attorney probably would have spent an hour on this as well. Same as last time. I don't feel bad about doubling up on it, even though it's mostly the same document, because there is going to be some overhead for my ex's attorney to catch up to the case. There are years and years of history in this case that he has to kind of get up to speed on because he's a brand new attorney on it, and he's going to have to ask my ex more questions, at least initially, than my ex's former attorney would, because she's been along with her the whole time. So I think an hour is reasonable. At the rate of $250 an hour, that's going to come to $250 in attorney fees for my ex. As in my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.